Hello everyone. Today in this video we're going to talk about topic the sources of Hindu law. We all know that our Hindu law is 6000 years old, and the study of sources of Hindu law is the study of various phases and development of Hindu law according to the changing needs of the society. The word sources is derived from a Latin term sordre, which means to rise, spring out. So sources is a thing that you get something from, and the sources of Hindu law may be classified under ancient source and modern source. Now we will discuss the ancient sources of Hindu law. The ancient sources of Hindu law is also subdivided into four parts: Shruti, Smritis, commentaries and digests, and custom. Now we will discuss one by one. Shruti. Shruti means literally which was heard. Like I am saying, you guys are hearing. Then it is called Shruti, which you are hearing. And it is derived from the Sanskrit root word shru, which means to hear. Basically, Shruti means that which was heard and handed down from generation to generation verbally. Here, there is no written, it is only verbally. The sources of Shruti was believed to be divine, and it is also believed that the very own words of the god revealed to inspire sages, and it is one of the most important primary and paramount sources of Hindu law. The article of belief of the Hindu law was that it is eternal, immutable, and relevant. They believed that it was the fountainhead of his law and it is supreme to the earlier Hindu. And it does not contains or it contains little legal values because it doesn't have any statement of facts and such laws as such. And Shruti basically consists of four Vedas, Upanishads, dealing chiefly with religious rites and the meaning of attaining true knowledge of moksha or salvation. By concluding, we can say that Shruti is a thing which was heard from generation to generation verbally, and it is also believed to be a divine source, and it is contained the very own words of God, and it also contains Upanishads, basically deals with religious rites and the meaning of attaining true knowledge. The next and the most important authoritative sources of Hindu legal literature is in Smritis. Basically, Smriti is a Sanskrit word from the root word smara, which means remembrance, thinking of, upon calling to mind, or simple memory. We all know that Shruti was the original utterings of the great powers, but Smriti is the recollection handed down from rishis or sages of antiquity and proclaim their recollections, and hence it is of human origin. Shruti is of divine origin and Smritis is of human origin, and Smriti contains of resembling the modern method of codification, and all the principle here and there scattered in the Vedas, and also those include in the Dharma Shastra as well as the customs or usage which came to practice and accepted by the society were collected together and arranged subject wise in a systematic manner. Like there are some principles in Vedas which are scattered, and in Dharma Sutras also there are some principles which are scattered here and there, and it also contains customs and uses which was practiced and accepted by the society, and all these together collected and systematically codified by the rishis, and it is also proclaimed that it is of human origin. And then comes commentaries and digest. The codification which we have seen in Smritis were very difficult to understand, and it also contains some form of verses and few conflicting provisions. So, the development of interpretation, which is also called Mimamsa, gave scope to the eminent jurist to contribute to the further development of law, which suits the changing needs of society and which also made the Shruti law practice understandable and workable. And the conflict provisions were even modified and supplemented the rules of Smriti by their own forceful reasoning or by referring to the usage that had developed and acted upon the society. This practice of writing commentaries or doing interpretation on a particular smriti gave way to a different trend of writing commentaries on different smritis together, and this type of work came to be known as digest and nibandhas. And many jurists have commented upon various smritis like the Yagnavalkya Smriti. It is basically a Smriti. This Yagnavalkya Smriti is commented by Vigneshwara, which was later became the Mitakshara school of Hindu law. And the same Smriti, the Yagnavalkya Smriti, was also commented upon by Jimukta Vahana, which later became the Dayabhaga school. Last but not least, customs and usages. Section 3 of Hindu Marriage Act defines customs and usage. Basically, it says that it is a rule which have been continuously uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group, or family, and provided that the rule is not unreasonable or opposed to the public policy. Basically, it says that it has been continuously and uniformly observed from a long time, which has not been unreasonable or opposed to the public policies. And the customs and usages is also defined in the case Har Prasad versus Shio Dayal. In this case, the Privy Council has held that a custom is a rule which is of a particular family or a particular caste or a particular community. It is a particular religious has from long usage obtained the force of law. For a customs to become a valid custom, it has to obtain the force of law, and it should be ancient, certain, reasonable, and it should not override the statutory laws. The essentials of valid customs are it has to be ancient, like the customs and usages has to be practiced in the society from the ancient period, and it has to be reasonable. It should not it should not oppose to the public policy, like a prostitute adopting a girl for the same purpose is not considered as a custom, though it is an ancient, because it is opposing the public policy. It is unreasonable. For a valid custom to be reasonable, it should not oppose to the public policy, and it has and have been continued without interpretations, and it has to be practiced or followed by a person in a particular locality or a group of persons, and the customs has to be uniform and obligatory. These are all the essentials which are required for a custom to be valid and to get the force of law. In the case of Lakshmi Bai versus Bhagavata Bhav, the Supreme Court held that the custom can modify general personal laws, but it does not override statutory laws unless the custom is expressly saved by it. It means that the custom has the power, because the law which we are following is based on customs, and the custom has the power to modify or make some amendments in the personal laws, but it does not override the statutory laws which are made by the parliament.